Welcome to episode 6 of FCLE Seminar, the Florida Civic Literacy Exam podcast. I'm your host, Mercedes Musto. The FCLE podcast is where we review American history to help you prepare for the Florida Civic Literacy Exam. Today, we are exploring a landmark Supreme Court decision that shaped our understanding of the First Amendment in Schenck versus the United States in 1919. This is all based on the guide put together by the Florida Department of Education. Hey, I've got the links to that study stuff in the show notes, so check those out. And don't forget to comment, like, and subscribe to our podcast at FCLE Seminar on YouTube. Got it? All right, let's get started. Landmark Supreme Court case number 5, Schenck v. the U.S. Case background. So what was the big deal with Schenck versus the United States? Well, let's see here. We're going to set the stage. It's 1919. This case takes place during World War I. And this is kind of funny to say, but 2 members of the executive committee of the Socialist Party, Charles Schenck and Elizabeth Bauer, I might have gotten that wrong, but decided to distribute leaflets to encourage a peaceful action of disobedience against the draft. Now, that doesn't sound so bad. So, what was the draft? The draft was a system to select men between the ages of 18 and 45 into military service to raise a national army. Now, you may have heard of that. The thing is, Charles Schenck and Elizabeth argued that the draft was unconstitutional, basically stating that the draft was a violation of the 13th Amendment prohibiting slavery and involuntary servitude. Key word, involuntary. See, the 13th Amendment, the 13th Amendment, this goes back to episode 5, Plessy versus Ferguson, where we talked about the 13th Amendment. And remember, the 13th Amendment to the United States Constitution abolished slavery and involuntary servitude. It states, quote, neither slavery nor involuntary servitude except as punishment for a crime whereof the party shall have been duly convicted shall exist within the United States or any place subject to their jurisdiction, end quote. Now, this Schenck leaflet stuff, this is pretty bold considering it was wartime. But it wasn't just about distributing the leaflets, which apparently there was like 15,000. Now remember, those leaflets also urged people to disobey the draft, albeit peacefully. So this is where things get real interesting, right? Yes. So Schenck ends up being charged with, get this, violating the Espionage Act of 1917. What? Explanation. This act made it a crime to interfere with the military or obstruct recruitment and was intended to prevent activities that were considered dangerous or even disloyal during wartime, like resisting and promoting the resistance of the draft. So how did that turn out for Schenck? I'm glad you asked. Schenck was found guilty and then appealed the case to the Supreme Court. Okay, more about the case. Now we're at the level of the Supreme Court, where the big question actually becomes nothing about the 13th Amendment and more about, was Schenck's conviction, the Espionage Act of 1917 thing and the whole leaflet distribution thing and the criticism of the draft thing and the disobedience of the government thing, was that a violation of his First Amendment right? The First Amendment. The right to free speech. Oh, that is interesting. Let me think about it. Here the court has to weigh in on the right to free speech against the government's interest in national security during wartime. Well, take a moment. Using your knowledge of the U.S. Constitution, how do you think the court weighed in on this? The court's decision was unanimous. And what did the court decide? The court ruled against Schenck. They upheld his conviction finding that the Espionage Act did not violate the First Amendment. Why? Well, the court introduced a new legal test called clear and present danger. This test says that the government can restrict or limit speech if it poses a clear and present danger to national security. Interpretation? The court basically said that Schenck's leaflets could have led people to refuse to serve in the military during wartime, which would have endangered the war effort. Now, here's the example that Justice Oliver Wendell Holmes used. He reasoned that the clear and present danger thing like this. He compared Schenck's leaflets and message to falsely shouting fire in a crowded theater. This is a super famous analogy, and it's still used today. So Schenck versus the United States is a landmark case because it established the clear and present danger test, which was used to balance the right to free speech along with the government's interest in national security. The constitutional principle. The constitutional principles in this case, established in Schenck versus the United States, is the clear and present danger test. This test allows the government to limit speech if it poses a clear and present danger to national security. In other words, the First Amendment protects freedom of speech, but in this specific case, Schenck's message during wartime had consequences interpreted by the court under the clear and present danger test. Whew. I don't know about you, but this stuff is getting kind of pretty interesting. Like, I just started out to try to prep up for this exam, but now I'm thinking about going to law school. How about you? Let's review. This case, Schenck versus the United States of 1919, involved a socialist who was convicted of the Espionage Act of 1917 for distributing those anti-draft leaflets during World War I. Next, this case established the clear and present danger test. This test has been used to balance the right of free speech, First Amendment, with the government's interest in national security. Pop quiz. Schenck versus the United States established a significant legal precedent regarding the First Amendment and the right to freedom of speech. But what was the key test articulated in this case, and how does it balance the right to free speech with the government's interest in national security? Multiple choice. Is it A, the Restriction of Free Speech Clause of 1919, B, the clear and present danger test, C, the direct and imminent danger test, or D, the Espionage Act test of 1917? Okay, you know D was wrong because I totally made that up. Come on, but you know this one. If you answered B, you are correct. The Schenck case established the clear and present danger test to determine when the government can restrict speech. This test balances free speech rights from the First Amendment with national security interests during wartime. Thanks for listening. Join us again on FCLE Seminar, a Florida Civic Literacy Exam podcast so you can start studying for your test. The important thing is to start studying and start studying today. Hey, what are you waiting for? Like, subscribe, and leave your questions or comments for us on FCLE Seminar on YouTube. This podcast is listener supported. Contributions can be made via the listener support link on Spotify, or you can buy me a coffee via the link in the show notes. This is your host, Mercedes Musto. Join me again on FCLE Seminar, a Florida Civic Literacy Exam podcast, so you can pass the FCLE.